Indian Constitution is a sacred document but not a static one. It allows it allows changes if the demand is made by the society after independence. Indian Constitution is a sacred document but not a static one. It allows changes if the demand is made by the society after independence. Several amendments provide provisions and laws were made for the need of the society. Ever since the constitution came into being, the political class and the judicial subjected it to multiply interpretations. Judicial pronouncement judgments have led to establishment of the several documents which was not mentioned in the original constitution, like basic structure, doctrine. The function of the National Commission for Scheduled Caste are to investigate and monitor all the matters related to the constitutional and other legal safeguard for the SCs and to evaluate their working, to inquire into specific complaints with respect to the deprivation of rights and safeguard of the Supreme Court, to participate and advise on the planning process of the socio-economic development of the Supreme Court scheduled caste, and to evaluate the process of the development under the union and state, to present to the president annually and at such other times as it may be deemed fit, report such upon the working of the other safeguards, to make recommendation as to the measure and Ministry of Home Affairs and the Department of the Personnel and Training. Promotion of scheduled caste employees is undertaken by the Department of the Personnel Training, and no such list of the maintained by the NCSC. Article 341, Clause 1 of the Constitution prescribes the procedure for regarding caste as scheduled caste as per this procedure, to make addition or deletion to the schedule by the amendment and the concerned presidential order for the state under Article 341, Clause 2. State government first proposed to modify the schedule. Only proposals agreed by both the Registrar General of India and the National Commission for Scheduled Caste are introduced in the bill in the Parliament. Directive principles list mainly three things: goals and objective that we as society would adopt, certain rights that individuals should enjoy apart from fundamental rights, certain policies and the government should adopt. The Constitution of India establishes a federal system of government. Its important features include two governments, division of powers, written constitution, supremacy of the constitution, independent judiciary, and bicameralism. The term federalism was nowhere been mentioned in the constitution. Article 1 describes India as a union of state, and which implies Indian Federation is not a result of an agreement by the states, and no state has the right to secede from the federation. Indian Constitution has been variously described as a federal in form but unitary in spirit. Federal in form and unitary in spirit. Quasi-federal by the KC, whereas quasi-federal by the KC, whereas bargaining federalism by the Morris Strong's, cooperative federalism by the Graham Austrian. A high court. A high court has administrative control over the control and other power over subordinate courts. These include the following. It is consulted by the governor in the matter of the appointment, posting, and promotion of district judges, and in appointment of persons to the judicial services of the state other than district judges. It deals with the matter of posting, promotion, and grant of leave, transfer, and discipline of the members of the judicial services of the state and other district judges. It can withdraw a case pending in the subordinate court if it involves a substantial question of law and require the interpretation of the constitution. It can then either dispose of the case itself or determine the question of law and return the case to the subordinate court and with its judgment. As a court of record, a high court also as a court of record, a high court also has a power to review and correct its own judgment or order or decision when though no specific power of review is conferred by it on it by the Constitution. The Supreme Court, on the other hand, has especially conferred with the power of the review by the Constitution. The Article 131 of the main is the main provision of in the Constitution regarding interstate dispute. This article confers upon the Constitution Supreme Court of India exclusive jurisdiction to deal with the disputes regarding legal rights and also disputes between the government of India and one of the more states or between the government of India and other and any state or state on one side and one or more states on the other or between two or more states. Article 25 covers not only religious beliefs, doctrines, but also religious practices, rituals. Moreover, these rights are available to all persons, citizens as well as non-citizens. However, these rights are subjected to public order, morality, health, and other provisions related to fundamental rights. For example, in Anand Mark case, the right to perform the Tando dance with the lethal weapons and human skulls in a public procession was held not to be an essential religious practice, and the banning of the procession in the interest of public order and morality was considered a reasonable restriction. Laws regarding public order, health, and morality cannot be violated in the name of freedom of the conscience of religion. The term preamble refers to the introduction or preface to the Constitution. It contains the summary or the essence of the Constitution. N.A. Pakiwala, an eminent jurist and constitutional expert, called the preamble as the identity card of the Constitution. According to K.M. Munshi, a member of the drafting committee of the Constitutional Assembly, the preamble is the horoscope of our sovereign democratic republic. In the words of the Sir Alladi Krishna Swami Iyer, a member of the Constituent Assembly who played a significant role in making the Constitution. The preamble to our Constitution expresses what we had thought or deemed to so long. The Constitution, Article 20 of the Indian Constitution, grants protection against arbitrary and excessive punishment to an accused person, whether citizen or foreigner or legal person like company or corporation. It contains three provisions: no ex post facto law. No person shall be convicted of any offense except for the violation of a law in the force at the time of the commission of the act, nor subject to a penalty greater than that prescribed by the law in force at the time of the commission of the act. No double jeopardy. No person shall be persecuted or punished for the same offense more than one. No self-incrimination. It states that no person accused of any offense shall be compelled to a witness against himself. The protection against self-incrimination extends to both oral and documentary evidence. It does not extend to compulsory production of the material object. It does not extend to compulsory production of the material object. Compulsion to give thumb impression, specimen, signature, blood specimen, compulsory exhibition of the body. Further, it extends only to criminal proceedings, not to civil proceedings. Only to criminal proceedings, not to civil proceedings or the proceedings which are not of criminal nature. The right to equality includes equality before law, equal protection of law, provision of discrimination on ground of religion, race, caste, sex, place of birth, equal access to shop, hotel, well, tank, bathing guards, roads, etc. Equality of opportunity in public employment, abolition of untouchability, abolition of titles. Equality of opportunity means that all sections of the society enjoy equal opportunities, but in the society, whether where there are various kind of social there are various kind of social inequalities. What does equal opportunity mean? The Constitution clarifies that the government can implement special schemes and the measures for improving the conditions of certain sections of society, children, women, and socially and educationally backward classes. In fact, Article 16.4 of the Constitution explicitly clarifies that a policy like reservation will not be seen as a violation of the right to equality. This is required for the fulfillment of the right to equality opportunity. Article 33 empowers the Parliament to restrict or abrogate the fundamental rights of the members of the armed forces, paramilitary forces, intelligence agencies, and analogous forces. The object of this provision is to ensure the proper discharge of their duties and maintenance of the discipline among them. The power to make laws under Article 33 is conferred only on the Parliament and not the state legislatures. Any such law made by Parliament cannot be challenged in any court on the ground of the contravention of the any of the fundamental right. Accordingly, the Parliament has enacted the Army Act 1950 and Navy Act 1950, Air Force Act 1950, Police Force Restrictions to Rights Act 1966, the Border Security Force Act, and so on. These impose restriction on their freedom of speech and right to form associations, right to be member of trade unions or political associations, right to communicate with the press, right to attend public meetings or demonstrations, etc. The expression members of the armed forces also covers such employees uh, such employees of the armed forces or barbers, carpenters. The expression members of the armed forces also covers such employees of the armed forces or as barber, carpenter, mechanic, cooks, chowkidar, board maker, tailor, that are non-combatants is